Something else happened this week that could wind up having a very big effect on how WWE and even other promotions like AEW do business. The state of California passed a bill that has not yet been signed into law, very likely, though it will be soon. It has support from the governor that would stipulate that independent contractors would have to be designated as employees while working in the state if certain criteria is met as set forth by the law. Per the San Francisco Chronicle, they say this. The California Senate on Tuesday passed gig work legislation. There we go, the gig economy. Ever hear about this gig economy? So anyway, it passed gig work legislation that could transform the state's employment landscape by turning many independent contractors into employees. The bill now heads to the state assembly, where lawmakers approved an earlier version, but they have to agree to amendments. If it passes a final vote there, AB 5 goes to the desk of Governor Gavin Newsom, who has said he would support the measure. The law would take effect on January 1st. State Senator Maria Durazo began Tuesday's debate by blasting tech companies. And I want to use this quote here because you tell me what this reminds you of. Blasting tech companies and some traditional employers, saying they have for decades exploited workers with false contractor labels. Remind you of anyone? Many traditional businesses across the U.S. have shifted to independent contractors as a way to reduce labor costs, but labor experts say they often misclassify workers as a way to avoid offering benefits like health care, paid vacation, sick time, and retirement plans. Assembly Bill 5, or AB 5, codifies and expands a groundbreaking California Supreme Court decision from last year known as Dynamex, which uses a simple three-part criteria, the ABC test, to determine employment status. It says a worker is an employee if the worker's tasks are performed under a company's control, if those tasks are central to that company's business, and the worker does not have an independent enterprise in that trade. So would this affect WWE? It very well could. It's still unclear, as to whether or not this would affect companies that are not based out of California. Some people seem to be of the impression that not a big deal. If you're not based out of California, it doesn't affect you. My understanding is that it doesn't matter. California is very strict when it comes to labor laws, and so WWE being based out of Connecticut and not out of California, it may not matter. If you run an event in a particular state, you have to abide by the labor laws of that state. And if they were to run shows there, the talent would need to be classified, if this passes, as employees and not as independent contractors. Now WWE runs about 10 shows a year now in California. Back in the 80s, there were some years where they would be running as many as 40 or 50 shows in California. Los Angeles, San Francisco, San Diego, Oakland, Anaheim, all over the state. So they're not running nearly as many shows as they did 30 years ago in the state. But even with 10 shows, that would be a big deal if they just decided to pull out of California and just not run there at all. They love going to California. They love going to LA. That's why SummerSlam was in LA for all those years before it came to Brooklyn. Hobnobbing with the celebrities. Oh, in the middle of the show, here's Seth Green in the crowd. Here's Adam Sandler in the crowd. Here's, Joe Blow in the crowd. Joe Dirt, whatever. So they love that shit. So for them to, let's say, pull out of California and not go back there, that would be a big deal. I can't see that, but we're kind of in uncharted territory here with this legislation. So, anything is possible. But I just look at it and I say, there's so much money on the line for the state. And them possibly running LA and that new stadium for WrestleMania in the next few years. LA is said to want WrestleMania there as early as 2021. That would be WrestleMania 37. Right? What are the two places that have been rumored? LA and Vegas, which also has a new stadium. And I can't wait for that. I am waiting for that new stadium to come to Vegas. Any excuse to go to Vegas, with a bunch of buddies, okay with me. But LA has been in the conversation as well. I think they have a Super Bowl coming there, and Supposedly LA wants WWE there first. WWE would rather they go after the Super Bowl. I think that's the order, right? WWE wants to go after the Super Bowl, right? So that they can, whatever attendance they give, they can say they broke the attendance set by the Super Bowl. That's kind of what they do. So for them to not run there and maybe not run a WrestleMania show there that the state might want to have, because WrestleMania does bring in a lot of money. Hey, look, it's possible WWE worms their way out of this somehow or finds some kind of exemption. They've done it before. These things have bubbled up. They seem to always, like, all these things always just seem to die down, and it's always just business as usual. It's possible that happens here too. You look at those 3 rules, and WWE stars would absolutely meet the criteria, it would seem, for employee status. WWE controls almost every aspect of their professional life. The work they do is absolutely central to their business. I mean, without the talent, there is no WWE. And they don't have the freedom to book themselves on outside shows. So they check all the boxes, it seems. More specifically, because I read the actual text from the bill itself. It's not very long. Anybody can find the text of the bill if you just search around online. That third part, here's specifically what it says. That third part says, the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. That's what you call a word salad. I'm still confused as to exactly what that means, but on the surface, it would seem that they do meet the criteria. Now, a lot of lawyers online, actual lawyers, not just fake lawyers like me here talking about this, have chimed in on this issue and seem to think that this could be a very real problem for WWE. There was one lawyer I saw, I forgot the website it was, but there was one lawyer who suggested a possible workaround for WWE if this were to pass could be for them to do something similar to what Hollywood actors do, which is, I guess each person would create their own production company, and that production company would then deal directly with WWE, with the idea being that the production company and the individual, they're kind of one and the same, but legally they would be different. We're getting into the weeds on this. I'm not sure how practical that is, but, WWE, here's the thing, though, that jumped out at me. And I haven't seen this reported in all the other stories, but, in this one story, it was said that WWE recently, as in this summer, hired a lobbying firm out of California. So a lobbying firm based out of California. I think they're based out of San Francisco. WWE has not said what it is for. They have not commented. They were asked about it. They did not respond. The firm itself, Greenberg Traurig, they're not talking. They're keeping mum on what this is all about. But they began lobbying on WWE's behalf on July 1st. So it's very possible, especially with them being based in California, that it has to do with the passage of this bill. Well, why would they hire a lobbying firm if this wasn't something that really would have any effect on their business? Why would they care? WWE has good reason to be scared. They've got labor groups now pushing for similar legislation in other states. They're pushing for it in New York. And it's probably all but a guarantee that at least some other states are probably going to pass some kind of similar type of bill in their own state. Now, again, they could just end up stopping running California altogether. They did that for years in the state of Oregon, supposedly because strict drug testing, and they had commission regulation, and probably the drug testing. They just didn't want to deal with that kind of outside testing that was mandatory. So they just didn't run the state. It was over a decade before they ran another show in Portland. Well, Portland is very different than New York. New York has always been like their home base. I know they're based out of Connecticut, but New York and the Garden, that's always been WWE's home market. Now, if something like this were to be passed in New York or in Illinois, would WWE seriously not run shows anymore at Barclays or MSG or in Chicago? Would they just pull out? That's when it becomes a big problem for them. But for now, still a little murky. how the California law is going to affect them. But if they're working with a lobbying firm, I'm telling you right now, that tells you that they are taking this very seriously.